Okay, I will call to order the city council work session with the planning commission to order. And first on the agenda, we have approval of the agenda.
I move to approve the agenda.
Second.
Okay, all in favor?
Yes.
Yes.
Aye.
Hi, Nancy. You don't sound good. Thanks for staying home.
Yeah.
Okay, so first we will have it public comment if there is any. Come on up.
This is the joint work session for wetland.
Yep, yes. Yep, you're in the right place.
In the right meeting.
Yep.
Jamie Lerma, P.O. Box 825, Canada. I have some questions and I guess I'll just read them into the record. I don't really expect anybody to stand up and answer them, I guess. My first question is, I'm curious why chapter 1743 is being addressed ahead of the other code section changes that are going to be proposed. Is there a deadline that we're trying to meet? And kind of a process question, I guess, is will all of the code changes that are going to be proposed be dealt with at one time, or will you be approving them as you make the changes? And some of these are based on the last meeting from March, but is there scientific evidence to support adjusting the buffer on all properties from 5 feet to 50 feet without consideration of different classes of wetland and individual circumstances? It seems that there would be circumstances or there would be situations due to topography or types of wetland that a 5 or 20-foot buffer would be adequate to protect the wetlands as determined by a wetland scientist. I believe that alternative methods of protecting wetlands should be considered and allowed. Well, what is the benefit achieved to our wetlands by changing the code from a minimum of one house per wetland lot of record to just one structure? This change could result in a 200,000 square foot site with 2,000 square feet of wetland being limited to one structure without evidence that multiple houses on the upland would impact the wetland. The current code protects wetlands by requiring all homes on wetland lots of record to be built on uplands when possible, and only allowing construction in wetland on buffer areas in highly unusual circumstances or when stringent standards are met. What is the impact on the city's housing policy, specifically the inventory of land available for housing? And then one comment, I think that the city should consult with experts now, early in this process, to evaluate the current code and make recommendations as the code changes are being developed. And that's it.
Thank you.
Okay, would it be appropriate to address some of the questions now while we're thinking of it, or
I
wait?
think the answers will come as part of our discussions.
I think some of them will, but some we may have discussed last time. So I could.
I'm still gonna bring some up
Yeah,
that are mentioned, so
so we could do as we go. I think the available science question, we won't have a need to address otherwise.
Right.
So we could go through that. That makes
Okay,
sense.
sure.
I think you brought up some great questions, and as we discussed, I think a lot of those will come up tonight. When you ask about the available science, to give you an idea of the 5-foot buffer adequacy, when we talk to people from state and we say, we currently have a 5-foot buffer, they look at us like we're nuts. So nobody does a 5-foot buffer for anything, any wetland. And so really the science says 50 feet's a minimum. 150 to 300 for a really high quality wetland. So given that we have urban wetlands, they don't need 150 feet buffer, to be honest, because we have so much hardscape around. We don't have beautiful rural wetlands that stretch for miles. But 50 feet really is considered scientifically about the minimum to maintain habitat and drainage to go into the wetland. I don't know if you had a chance to look at the packet that was circulated tonight. There are ways in which, if you really have no buildable property, we are proposing, and this is something we have not discussed in joint session, that at some times that buffer could be reduced by 50% to 25 feet if you're dealing with a lot where you really have no upland. So we recognize that there may be times when that 50 feet makes the lot unusable. And in that case, we as a city do have to recognize that people have a right to reasonable use of their property. We've also included an option for buffer averaging, which means that if you have one wetland and a surrounding buffer, if you can say, well, I can increase the size of the buffer in one space, but reduce it somewhere else, still maintaining the same square footage of buffer without hurting the wetland, that would be allowed as a way to make the property buildable. So we are thinking about that, but the science tells us that 50 feet is really the right thing. And a lot of cities in Oregon that have got beautiful wetlands are protecting their wetlands with 50-foot buffers. You asked about the quality of the wetlands and, how do you say that every wetland in the city needs this? So the state of Oregon under Goal 5 requires that for what are called significant wetlands, you must protect them really well. That means like a 50-foot buffer or equivalent. We have wetlands that are in the middle of the city. So these may not have the same biological functions as what the state defines, but ours are significant for a different reason. And that is that they provide an amazing amount of flood control on a day like today. You can imagine we need all the flood control we can get when we get a downpour all of a sudden. They all are also really important for water quality, especially in an urban setting like we have. They do a lot of keeping pollutants from spreading into the environment. So runoff from streets, et cetera. So our buffer is intended to keep the wetlands that we have, which are really quite minimal, to be honest, functioning as best they can for what we have.
Can I add one thing?
Yeah.
And also, we didn't just sit down and make this up. We did consult with state agencies, and Marcy also has read through this and knows what's in it. She's the consultant the city has hired, and it will be run by an attorney as well, who deals in land use primarily, to make sure that it passes muster legally. So.
Okay. Anybody else? Any more public comment?
We have one on Zoom.
Oh, okay, sorry.
Hello.
Mike?
Hi,
Yeah.
Mike.
Hi, Mike Morgan. PO Box 132, Cannon Beach. I just want to clarify that, and I'm not talking about any specific piece of property, but where you've got a large parcel and a tiny amount of wetlands, that the lot of record rule does not necessarily apply to that large, to the entire parcel. It was a little confusing about the change from one dwelling to one structure. I don't know where that came from, but I'm not sure that makes a whole lot of sense. The other thing I'd like to say is I have no consulting or economic interest in the wetlands down at First and Spruce. I'm not involved in that project at all, but it's having looked at that parcel and the various development proposals that have come along for many, many years. It just seems like even if they were able to somehow have a 50-foot or 25-foot buffer from the wetlands, which is basically just a ditch. I mean, let's face it, it's a ditch. The water flows out of Elk Creek, the little park behind Nicola Square, and along in the right of way, and then it flows through a culvert into the Little Pompey wetlands. But even if they were able to have, 25 feet, what kind of resource value would that buffer retain? It would still be a gravel strip, maybe used for dumpsters and parking lots, because that you're not requiring that they restore the buffer. You're just saying they have to stay away. They have to stay away from the actual wetlands that distance. So I think you need to think about, in an urban setting like that, how that's going to work. The other thing I want to say is, I think goal 10 is an issue here. If you're going to limit the number of housing options in Cannon Beach, take away buildable land options, I think you could very well be out of compliance with goal 10. I would love to see a multifamily development downtown someplace, like on First and Spruce. But I don't think it's going to happen under, if you're requiring a 50-foot buffer. And so anyway, that's my comment. I think some of the provisions in the draft that I've read seem to be rather punitive, and aimed at specific parcels. I think you need to have. I understand Marcy's got a colleague that's going to be involved in the drafting of the wetlands code, but I think you really need to put the brakes on it and have some professionals who have been involved with land use code look at it for quite some time. So that's my 2 cents. Thank you.
Thank you. Anyone else? Okay, so we will go ahead and start our discussion.
You want me to start off?
Please.
First, I feel like everyone's coming to the same conclusion, and that is it's time to pass this on to the experts. So my hope for tonight is that we as a group can go through and make sure we all are comfortable and agree on where we want to see these provisions end up. So that means we make some changes tonight, and then it's time to pass it on to the people who can review this. For instance, the planner at DLCD will definitely take a look at this. We need to pass this on to the attorneys. And I believe this is why we'd hoped Marcy would be here. Maybe Bruce knew something, that Marcy will have an expert who can also weigh in. So my goal tonight is that we just talk through and say, what do we want to see? And then let the experts take over and tell us how does that need to be done and how does that need to be changed to be compliant with state requirements.
Okay.
And I would propose that we go section by section. So we take a section and we say, okay, here's the main idea, what we were doing here. What are the comments?
Okay, sounds like a good approach. Everybody agree?
Mhm.
Okay.
So first section is 1743-010 purpose. The changes here from last time include the ability for the city to hire an independent expert if they receive say a wetland delineation or a mitigation plan, so that if there's a questionable recommendation there, the city can have opinion on that. And then we've added definitions. Certainly in our last session, we pointed out there were a lot of terms that were hard to understand. And if people have ideas for more terms to go in this section, please let us know. So I'm ready now to take comments on 010.
You asked for editing comments, so.
Yeah, please.
Last sentence, well-being, I think that's hyphenated.
Okay.
Section D says competent authority. One of the things we have talked about trying to accomplish with the revisions we're making, not only the wetland, but also just the zoning code in general, the municipal code in general is being as clear as possible. And I'm not sure competent authority does that. We may need to be more specific about that, or maybe we can't. I don't know, but I just put a question mark next to competent authority.
Okay.
Could we just put permitting in on that one, right? And that would be the same thing.
It could also be like a state authority versus a city authority. Barb, did you have a thought on that?
No, I didn't hear what Mike said.
Oh, I was just thinking it could easily be permitting authority, and it's a term we've used throughout. So, but I guess we need to look at it.
I will definitely mark that as how do we make sure that it's clear and objective?
Yeah, what's the intention?
The intention there is that
I mean, we've used qualified wetland professional farther down. So is this different?
so this would be any activity that had been permitted before these revisions are passed. So maybe Mike's right, permitting authority is enough, but we just need to make sure that encompasses any possibility, because maybe there's, say, a state permit, but if we define permitting authority as beyond the city, so either state or city permit, those are all grandfathered in.
Well, adding permitting authority to the definitions then?
Yeah, there are other places we've used approval authority, meaning the city's approval authority. So we should be very clear about that.
So we would certainly be competent.
Right.
I also wondered if we should define what a wetland survey is here.
What a wetland survey is?
Yeah, how we define what a wetland survey is. We define who can prepare one, but what is a wetland survey? What do we accept? Put another way, there's a number of wetland surveys already in the city's inventory referenced on the wetland map.
Oh, I do have a comment on this. I would suggest the term wetland delineation. That is the term that we do use, and that is what the what Department of State Lands uses as far as the document that they approve. Is a wetland delineation.
Oh, I think that's good. That's, yeah.
Yeah, so maybe that, put that in there. And then, and I don't know if this needs to go in. Later, there's a reference to mitigation, compensatory mitigation. Maybe define compensatory mitigation plan. It's used later. It's used in I think it's used federally, and we may want to just touch on it here. I'm not sure, but I just had a note.
So,
Where are you, Clay?
so compensatory mitigation is a state requirement sometimes if you fill a wetland. That is defined by the state. So I don't know if we need to define it here. We do not allow city level compensatory mitigation.
Okay. Lisa, I was just coming up with definitions. It's something that's referenced later in the package, and I was suggesting maybe we need to define.
Yeah.
Oh, I see. Okay.
I think
was
if we
it for me
used
on
it
that
at the city level, we would need to define it. But since when we mention it here, it's just relative to state permitting, I feel like that's their definition.
Okay.
But thanks for the idea. All right.
Anything else?
Well, I had a few thoughts, and so we're talking primarily on the definition
Yes.
section, and I felt like that was an area that we really could beef up,
Okay.
in my opinion, and I did make a list of some of the terms that I came across as I went through it, so I'll just mention them now.
Let me make a new list for definitions.
I didn't think I don't think we would define what a reasonable use is, but we'd set that as a standard against what an owner can and can't do, or
I do define that a little bit here in the new version. So but let's talk about that in 025.
right. I mean,
And
so
if it
these will
doesn't-
come up
If it doesn't
later.
answer your question there, I think that it's a good idea to come back to
Okay,
it.
well, let me just give you
Yeah,
the other ones.
Let's get those.
Resource area,
Okay.
a defined, some kind of a definition on what a enhancement is in our view. I think we need some kind of a definition around mitigation. You know, what is that thing that we're trying to achieve? What does the city
Yeah. I think it's such a big
Before.
picture
Well,
thing that we can't put it down
it
as
is,
one
but
definition.
When
So I
we
feel
get
like,
to it.
yeah, let's talk about it there and let's see if we can define within that section, because I feel like I would want to put 2 sentences to sum up mitigation.
I don't have a problem with that. but-
Sounds good. But let's come back to that. So I'll mark that as something we want to make sure you feel is.
And the only other one that I've got written is a little bit of a better definition of exactly what the wetland overlay zone is.
Okay. Let's talk about that when we get to that section, because that's really important.
I guess I have one more. Wetland buffer areas, number 8 is actually repeated from up on that same page.
Okay.
And I don't know that that's necessary. It's also listed under on the page.
So which,
But it was.
where is
struck
it?
out in 4.
Oh, sorry.
Yeah, I don't see it listed above.
It's
in the-
104.
This is a new draft.
Might be looking at your compare version. It lost some of the changes.
Did it really go up?
Yeah.
I did, and so maybe some of my stuff shouldn't be.
Yeah, I
on there.
think, Mike, you weren't here when Mike pointed out, there was, when you did the compare, it actually lost some of the changes. So
My
it's actually
apologies.
struck out in 4.
Okay, then,
Yeah.
So we're referencing what was in the packet.
right.
Okay. Well, then we're okay with wetland.
Yeah.
Areas.
Right, it is. Yeah.
It got it.
Yeah.
All right, got
Yep.
it. Okay.
Other things in this section.
All right, great. So 020, we really didn't change much. That's the mapping. We want to add new standards to update from 1987. Unless anyone else had thoughts on 020, I think we can move on to 025.
Just one thing that I think we ought to touch on as a part of this is the actual maps. I've been to these a number of times and maybe it's clear to more people than me, but I go to the maps and I'm confused. Robert, I don't know if you can pull those up or not, but we do have, the city does have a number of categories that seem to me to overlap relative to what we're calling a wetland or a buffer area. And in any case, those maps should probably align with the language we have here. And I don't think the way I read the maps last, they do. Robert, are you able to pull that up?
Yeah, I'm just getting that right now.
Okay, great.
So this is the online GIS map.
So Clay, do you want to explain to us what feels like it's not cohesive there?
Well, I'm already rattled because when I go to pull up maps for Cannon Beach, I get a different screen. But in that screen, it's tough to explain looking at this map, but I'll try. So Robert, I don't see where green is defined. What's the green and what's purple? Is that the actual wetland?
Green is wetland and purple is affected.
Correct. So the green is the local wetland inventory area. So that's what was mapped in 1991. The purple are the wetland affected tax lots, meaning that they are touched on by either a wetland or a stream. And then the streams are the blue lines.
Okay. This map is different than the one I've been looking at, so maybe it's just a me thing. This is a little clearer to me than it's funny when and you obviously know how to get to this faster than I can or can ever, but when I looked at this afternoon, I get a different set of maps. But if this is there, then I'm not going to worry about it.
Might be good to get your comment anyway, Clay.
Yeah, let me see if I can find him here real quick. And maybe I can share.
Wow.
All right, so I just put in City of Cannon Beach wetland inventory. And let me see if I share my screen, will it show up for everybody?
Let me see if I make him a co-host.
If you go into share screen, allow multiple users, can you do that?
Screen.
The whole, yeah, he should know how to
Okay.
share.
Okay, you should be able to share.
All right, I'm gonna try that now. What screen are you guys looking at?
I think I see your desktop.
Okay, do you see?
That's here than
Can't
mine.
Beach now?
Making you feel pretty.
Yes.
Y'all feel better about your desktop?
Show my desktop.
It could have been worse. All right, so this is the map I was referring to. When I Google City of Cannon Beach wetland inventory, I'll go back one. I get these sheets. And I assume this button over here is what you were pressing, Robert, to get to that GIS map. I'm not sure where these exist, how I got to these other than the Google I hit. But if I go to any one of these sheets, I have this map with this inventory, local wetland inventory areas, affected tax lots, and wetland delineation reports. So the little yellow dots are the wetland delineation reports. The green is the local wetland inventory, and then purple is an affected tax lot. It's not clear to me why a property would be in the wetland inventory but not be an affected tax lot on this map. So I think, and again, if the city's not using these maps, if this is an old path, it's no longer on the city's website, let's not worry about it. But
Yeah, it's obviously on the website, but I've never actually used these maps before. All the ones I've seen have been through the online GIS system, but they're probably similar in the information they show.
this is the difference, though. This legend, I just think that we use different terms for delineated wetlands, affected tax lot, wetland inventory, and it would be good to make sure that those were aligning and that everybody understood the difference between a piece of land that was cataloged as being in an inventory area versus an affected tax lot. So like right here, I don't know if you all can see my cursor, but I'm touching on tax lots. So they're in a wetland inventory area, but for some reason they're not affected. I don't know why. There may be a very logical reason. But I don't think it's clear.
Looking at the maps that you have pulled up, it looks like those maps were the maps that the GIS maps were built on. And so if on the GIS map, you just drop off the layers. So if you dropped off the local wetland inventory map, the affected tax lots is still there on the GIS portion. And so the green disappears, but the purple's still there. And the purple is still visible marginally on the map that you have there underneath the green, like the green's the top layer.
Oh, it's 2 layers. Interesting. Okay.
Yeah, it looks like it's like how many ever layers are there? So 3 or 4 layers.
Okay.
But yeah, it looks like the purple is an underlying layer below the green, and it's just not visible because of the overlapping layers. But on the GIS, you just drop off the local wetland inventory portion, and it shows those lots as being affected tax lots indicated by purple.
Got it. Okay.
I thought he was saying that anything obviously in the wetland would be an affected tax lot, but they don't show up here.
I think that's what his question was on that map that's there.
He's saying underneath.
I'm looking at it.
Mhm.
I've got affected tax lots and the wetland inventory.
Mhm.
And if you take it, you can kind of see, or even if you take away the wetland inventory, there are lots there that are not purple. So, yeah, I guess I'm curious about.
I'm familiar with what you're referring to.
Oh, I think I see which ones you're the ones that are like south central into that one wetland. That it's like 2 lots, 3 or 4 lots.
I guess I'm looking at the map where that area is wetland 19.
Mhm.
And at the bottom portion of that, There are. I mean, they must be lots, right? I mean, maybe they're not lots.
You know what? I think this might be a database issue. It's not a code issue.
Right.
I think we should probably take it offline and fix that problem. And offline.
Yeah, maybe that's the answer, Mike.
Although I would also be curious, is there any kind of buffer indicated here on the affected tax lots?
Affected tax lots probably take into account that 5 feet.
Yeah, I'm not aware of any buffering being shown on the online
Yeah.
maps.
But I think it's probably just because some of these affected are just outside the edge, which makes me think the buffer is included in the green.
So if we aren't including the buffer on the wetland inventory here, then our affected tax lots obviously are greater.
Well, 5 feet probably doesn't make much difference right now.
But it does bring up a point. When we're done with this, we need to pick the GIS, right?
Yeah.
Correct. There are a number of things with GIS that need to be updated.
Yeah, okay.
I'm gonna stop sharing if that's good with everyone.
Please.
The GIS mapping is much more convenient
Yeah, for sure.
with the different overlays that you can remove or add.
Mickey, you had said that, so that was my larger concern. I have some minor concerns, but I don't want to hog time just in this mapping section.
You want, if they're easy, you could email me
Okay.
with a bullet list.
Are they
Be fixed.
editing changes?
Yeah. just-
Okay.
Okay, yeah. And anybody, by the way, is welcome to send me editing changes. If you see little misspellings, et cetera, just send me a list. Let's see if we can make sure that we're happy with the big picture.
The content.
The content, yeah.
I did have a bigger picture question, and that's under.
Okay.
Can you help me understand what that means?
Under what?
Section E under mapping.
The
I had the same question.
protected wetlands are legally filled. Okay, so some of those affected lots, for instance, in the GIS map we just looked at,
Yes.
used to be wetlands, were then built on. They are no longer marked as a wetland when you look at the GIS map, but they are still considered an affected lot, for instance, on the GIS map. And I think this is similar. It's saying if you filled a wetland on your property, you still are subject to the provisions of this code. So in other words, it remains a wetland lot of record, even though maybe the wetland was destroyed. If you look at Hemlock Street off of Fifth and Hemlock, you'll see there are a number of lots there that have wetlands on them, but then they allowed them to build. So they no longer show up in the wetland inventory, but they are still affected lots.
Okay. Got it.
Yeah.
I still have a lot of questions about that. In what kind of time frame? I mean, Cannon Beach is pretty much filled. We've filled our wetlands and now we're trying to save the remaining ones. First and Spruce. I'm sure a much bigger wetland, but it's been filled. So is that wetland buffer?
No,
Because there's still an active wetland there. There's a delineated wetland at First and
and
Spruce.
the buffer goes 5 feet into the fill. All this is saying is if you fill it, it doesn't mean that it's not either part of the wetland or part of the wetland buffer. You know, if it's within the buffer, it's still buffer, right? So taking First and Spruce, all that fill, you know, is no longer wetland. It could be part of the buffer. It's not, as the wetland was delineated, but if it had turned out that the wetland had been wider, some of that filled area up to 5 feet would have been buffer.
Okay,
Basically, I think the code here, this is original language.
The old language.
This is original language, but I think it makes sense. Because what it's saying is you can't just get rid of a resource by filling it, and now you're no longer subject to any protective measures. Do we have anything else on 020 mapping? Here.
oh yeah.
Okay. So move on to, this could take a while. So this section, we have made a lot of changes to. So I want to make sure that everyone is comfortable with what's happening here. as a big picture explanation of what we are attempting, and I would love to hear feedback on whether we achieved, is to basically create a priority of steps to make a lot that is, say, so covered in buffer or wetland that it is unbuildable, to give the owner of that lot the ability to build something. And there was a question, oh, he left. There was a question earlier about dwelling versus structure. The idea there was that this original code said one residential dwelling unit. So it means you could put a single family home there. We broadened that to be a structure so that you could say, for instance, have one structure that would house two families. Or we also said, why are we not allowing a commercial structure? So actually the people at First and Spruce should be happy with this change, because conceptually what it means is that we're saying the owner of a lot, whether it is a commercially zoned or residentially zoned lot, should be allowed to put something on the lot. And so we want to go through a series of steps from least impactful, right? Least impactful to the wetland and wetland buffer to most impactful. So the step one is to say you can do buffer averaging. So if you don't have enough upland to put a structure on your lot, you can do buffer averaging, which means that you can say, well, I'm going to come into the buffer by some amount in one space. I'm going to make the buffer smaller so that I can build here, but at another point in the wetland, I'm going to increase the size of the buffer so that the total buffer area remains the same.
On the same lot.
On the same wetland, but maybe one spot is now narrower, one spot is wider. Go ahead.
I get the averaging, and I think it's a fascinating idea. But how do you take into account that by minimizing the buffer in one area, you may be actually doing more impacting on the wetland than you're gaining by increasing the buffer on the other part of the lot?
And there is a portion of this provision under buffer averaging that says, where is it?
Will not result in degradation.
Right, does not result in degradation of the wetland functions. So that's something that your wetland specialist would need to analyze and say, if we reduce it by so many feet here, increase by the same number of feet somewhere else, we haven't hurt the biological function.
The reason for this whole thing is because of the way the state law is. I mean, we have no choice. In other words, we can't deny anybody the ability to put a structure on a land. Yeah.
I understand. I do understand that. I have a follow-up question, if I may. So we talk about the wetland experts, right? Is the city going to provide a list of approved experts, or can any homeowner decide to find the expert which may or may not be aligned with their needs?
So in definitions for a qualified wetland expert, which is 010 E5, we list a couple of different ways in which a qualified wetland specialist or professional can be qualified. And this is taken from Pierce County in Washington State. They're, to my knowledge, one of the few people who's actually tried to define what a specialist is. So that's the best we can do. I think it's better than creating a closed universe where we say, here's our handpicked group, but other.
To take your comment or the answer a little bit farther, the city also retains the right to hire a qualified wetland specialist. And so that I think actually incentivizes the applicant in most cases to hire a competent one that's not willing to compromise on his.
Okay, I just know that
Professional.
sometimes the best intentions get away from us. I just want to make sure that we're not opening ourselves to a situation where decisions could be made by experts that are not necessarily aligned with the vision of the city.
Always a risk, but the best defense is to go find your own expert.
And I do have a comment, just kind of an administrative comment. We, the city, can't recommend private experts. As far as contractors, things like that, we can't recommend a private service provider because that could arguably show favoritism to a provider. So that's something we can't provide a list as far as, who we would suggest.
Thank you.
And I should come back to one comment that Les raised earlier about reasonable use. So in section B here, before we begin talking about the steps for making a lot functional. We defined reasonable use as 1,000 square feet of impermeable surfaces. So if you don't have upland that allows you that much impermeable surface space, so 1,000 square feet, then you get to take these steps. So that means reasonable use is at least 1,000 feet of upland area. So if buffer averaging doesn't create enough area to place a house of 1,000 square feet, then we can move to the next step, which would be to allow a buffer reduction of up to 50%, not necessarily 50%, if that's necessary to create enough buildable space to accommodate. I think we had 1,000 square feet again of impermeable surfaces. So this is again the reasonable use. And along with the buffer reductions, we would also allow potential setback reduction of side, rear, and front yard setback. So that would be step 2. First, you try to buffer average, keeping the same size buffer. Step 2, you're actually reducing the size of the buffer to allow a reasonable use. And if neither one of those creates enough buildable area, let's say you have a lot that's basically just a wetland and we don't have room to reduce buffer there. The final step would be to allow encroachment, a minimum amount of encroachment into a buffer or wetland area to build 1,000 square foot footprint. That means your house itself can go up by 2 feet or your structure can go up by 2 stories, sorry, but you'd have a impermeable surfaces of 1,000 square feet. So that's the priority system that we were attempting to set out here. So very open to comments of any kind.
Oh, are you going to address where we took out under 2A,
Yes.
the applicable zone designation?
Yeah. So I think big picture would be super helpful to know, are people comfortable with this system of trying to render a lot functional?
This particular section is deeper than I was able to dive. I'm a little concerned about the like, for example, starting with changing the date. The crossover between federal and state and all the agencies that were involved in the early 90s on this and back to before that. I'm worried that we might be crossing over something that's federal, and you've dove a lot deeper on this maybe than I have, but I'm worried, like, for example, it was 8/24/93. Clinton issues an executive order. It's the Wetland Protections Initiative. It has 40 different protections for wetlands, and part of that is creating a more streamlined process for wetland owners not to have to go to court to be able to settle this, to be able to resolve their issues with state or local jurisdictions. And I think part of that initiative was where this language wetland lot of record comes from. So if we start to move away from that date as the date that wetland lot of records are created, are we then moving away from that whole set of protections and getting ourselves away from the federal protections that were put in place? The other thing that I'm a little worried about is moving that date from the date that the ordinance is put in place from August 4th, 93. And I think that might have been a typographical error. I think that was should have been August 24th, 93, which is when that executive order went in. But my concern is potential Measure 49 claims. We have kind of a tried system. We have these lots of record that people understood on August 4th, 93. They had, and if they were going to fight over it, they brought those fights forward on a 47 claim or 37, I think, before that. If we change as a local governmental agency that date, we potentially open ourselves. And I don't know this, maybe this is just put a big asterisk next to it with the attorney, but I would think there would be the possibility of Measure 49 claims. People coming in and saying, hey, this government's come in and changed the rules on me, even though our intention is to try to get more protections for a house or a structure. Maybe they come in and say that, I had a 5 acre, I'll make this up. I don't think we have a 5 acre. I had a large site. They're telling me I can only get one structure on it here, and look, they just changed the law in 2023. So again, I don't know, it's not my area of expertise, but I do know that if we change that date, I shouldn't say no, I'm concerned that if we change that date, it may take us away from the federal regulations that it was intended to follow, and it may open us up for some kind of Measure 49 thing. Again, I don't know that, but it occurred to me those are possibilities.
I think you're right. We should asterisk that for an attorney. I'm not picturing right off the bat how we could be opening ourselves up. The federal protections are not particularly meaningful, to be honest, at this point. In terms of Measure 49, I feel like it's more protective to say you're grandfathered in until very recently than grandfathered into an older date, but that's something we should definitely ask an attorney.
Good.
You actually capture a lot more.
Right. Dorian?
I'm confused about one thing. You've been talking about the 1,000 square feet.
And I had a 1,500 square feet in here that needs to be,
That's a typo?
it's a typo. Yeah.
That's the easiest question of the night.
Thank you. I like those. Lisa caught that earlier. She said, what's this about?
I'm just thinking, what federal protections
I think it was, it
for a local jurisdiction? There are no federal protections.
would have to be a federal water, and none of these are navigable water.
Right, yeah, it has to, or, the fish bearing stream thing, something that involved the Corps of Army Engineers. But we have nothing like that here. So I'm not sure how that's not worried about.
I'm definitely not sure either. I just know that date is not random. Under 3A.
Yes.
Somewhere else. We talk about the same ownership.
Right.
So if I have Clay 1 LLC and Clay 2 LLC, those are legally separate ownerships. Maybe some language in there that protects.
I'm trying to think how you could do that, because can you legally say to someone, well, you created 2 LLCs, but I know you're behind them both. You know what I mean? Like, I'm not sure we can legally sort of force people to dig underneath the ownership of an LLC.
Good question for a good attorney.
Right.
Under C, just email, that one's not a big deal.
5C.
3C, because I brought it up, I'll say it. First sentence, second line, environmental assessment.
Yes, and so we are going to be changing the wording of this so the environmental assessment's not there, because I realize that's not defined.
Yeah.
Is that wetland delineation?
This is actually it's more than a delineation, but I think that we don't need to define it as evidenced by an environmental assessment, because all we have to say is the application of the wetland overlay zone to the latter parcel precludes, because we already have a wetland overlay zone. We don't have to provide evidence of what that is.
Right.
So we just take the as evidenced out. To be honest, I borrowed this from another city's code, and that term stayed in because they do things differently than we do.
So all of these, all reasonable use statements that are kind of stacked up.
They're all gonna
refer
come back to that,
to the
right.
one.
So that's
But
the
I have to
question.
understand that it
Right.
only applies to this particular,
Yes. Just this section.
to the uplands. I'm not even sure what it.
So
applies
what it
to be
applies
honest
to
with
is
you.
to say, and this was something I think came up a little bit in the public comments. People said, well, you're limiting us. We can't build on a big lot, all we get is one house. And the idea is if you have a big enough lot, and we'll get to this later with land division. If you have a big enough lot that you have lots of uplands and you can subdivide it and you can put in more than one structure, this code still allows somebody to do that. So really, when we're talking about reasonable use, we're talking about a lot that has become so impinged upon, let's say, by wetland or wetland buffer, that as we read the code, there wouldn't be enough space for 1,000 square foot footprint. So then we're saying we need to give them some ability to use that lot. And that's what the reasonable use is. So it only applies to those lots that have such limited upland area that they need more than is currently on the lot. So if you could picture it like this, it's like saying, look at your lot, how much upland do you have? If you have less than 1,000 square feet, we're going to find a way to help expand that so that you can still build.
And I thank you. And with that explanation, I understand, but I don't get that necessarily
code.
directly from
Yes,
one
yeah.
reasonable use statement.
okay.
I mean, sorry, that's kind of the way.
No, that's what we want to know, because people need to be able to read the code and understand it.
Yeah, I mean, to me, it just gets back to very subjective, and what's reasonable to me isn't reasonable.
Right, so we
to
need to be
you.
really clear, yeah.
I do get the sense of where you're trying to get. Thank you.
Right.
It is.
And this is the kind of thing that I'm hoping, say Marcy's consultant, who's done this a lot, will say, oh, here's how we say this. So, what we're doing tonight is hopefully becoming comfortable with the actual content. And then we're going to get someone who's an expert at the language. But I definitely will do my best to find reasonable use here so that it's.
Well, I think in section B of that at the beginning, if you just reorder the two sentences in there.
That's true, right?
And to start off with reasonable use is defined in this section as.
Yeah.
And then
Yeah,
and it's you have all the information in there technically. It's just kind of
yeah,
Right.
a little clunky-ish.
Yeah, that could be
that's
good.
perfect.
Yeah.
Whereas I was thinking it should go into the definitions that group right up there front. I just felt like it needed, because I obviously didn't catch it. It
Okay,
needed to be more
no,
obvious.
this is the kind of conversation we want to have. Do we have anything else on 025?
Are we going to read the new language under 2A? I don't know if anyone, they haven't seen that.
2A,
Under 43025,
yes.
2A.
Just this morning, we were talking about further revisions. So we will remove, so 2A right now reads the application of the wetland buffer to the lot or parcel as evidenced by an environmental assessment precludes all reasonable use of the lot or parcel under the applicable zone designation and renders it not buildable after consideration of all applicable limitations and restrictions. So we wouldn't remove as evidenced by an environmental assessment, also would remove under the applicable zone designation. So we would say it just precludes all reasonable use of the lot and renders it not buildable. Okay. So we want to move on. We have 030. So these are permitted activities in wetlands. Not changed from the last time we looked at it. So unless someone has comments, this is the same that you saw last time.
Sorry, Vicky, can we go, I hate to move us backwards,
No, it's fine.
but in 2B, this is part of the effective date in 1743-025A,
Mhm.
and you removed the date in A. So what date is it referring to?
So in A, we have an effective date, which is we've named it as the implementing date of this ordinance. So whenever it's passed.
So that would
So I
be
have the
A.
square brackets there. It will become a date but I don't know what that date is.
Okay, so that's what that's referring to.
Right. And so the effective date in capitals means it's always going to come back to whatever that implementing date is.
Got it.
So as I say, we didn't change anything in 030 or 035.
I did have a question about 035.
Okay, go for it.
I think it's 17, in that first paragraph, it references issuance of a development permit in accordance with section 1792.010. I don't know if it's that section or 1768.020, the last, but one of them talks about our permitting process in the city and says that those permits can be issued either type, I'm not going to get this exactly right, but the gist of it is this: the type 1, the development permit, and the basically the permit for the structure could be the same permit. So someone could come under a type 1, the way this is written. In my understanding, the way this is written, someone could come under a type 1 application, have their wetland approval and the building permit in one application. Is that okay with this group? Or do we want it more along the type 2? Where there was, among other things, notification of neighbors and that sort of process, or just leave it alone and keep it as is. It was a question, though. I mean, as we think about our process in the past being imperfect, this is an area that might be worth talking about. What kind of approval process do we want for a property that sits in a wetland? Is it just business as usual, or is it a little more regulated?
No, you're right. I think a type 2 would make a lot more sense.
We should get, Robert, how are those used, those type 1 and type 2 designations by your?
So type 1 is basically a residential structural land use authorization. Type 2 would be if you were to go in and do any sort of grading, clearing activity like that, which might be part of that residential permit, but usually there are 2 separate permits that go out.
Okay.
And then under current language, if you're doing any sort of excavation, grading in a wetland or wetland buffer, that would be a conditional use. So that's the distinction there, is that the type 1 would be the house itself. The type 2 would be any sort of grading, vegetation clearing, stuff like that, associated with that process.
So you, as the planner reading this, would understand that if it's a permitted use, you would go to either type 1 or type 2 and make a decision based upon that.
Correct.
So, Mickey, I think the street you used to live on has some houses that are in wetlands that were approved. I'm going to guess under type 1. I have heard from people saying they were from citizens concerned that process did not have enough eyes on it. It wasn't handled as if it were a wetland. So, you know, if we're going to change that process at all in terms of eyes on it.
Stay tuned. That issue might come up in a planning commission hearing in the next week.
I really think this is important. And I think we do need to revisit this and make sure it reads appropriately. Robert will be taking a look at whatever we come up with tonight. And I'm hoping, Robert, you could help us be really clear what we're actually achieving in the way of the types of approval that will be required.
I'll
So
do my
let's,
best.
right. So let's get some clarification how this would be read by a planner so that we know, and then we can move forward in making sure that it's a process that does have opportunities for citizen notice, et cetera. Ready? Okay. We move on. Okay. So let's see, additional use even activities. So 040, 045, again, we didn't touch since our last joint session, but if people have comments, feel free to bring them up.
One thing we don't touch in here is non-point source stormwater.
We do.
We're gonna get there in just a minute.
We do? Okay.
Yeah,
I-
We're
I
gonna
didn't
get
see
to,
it.
stormwater is gonna get a highlight treatment.
And then alternative stormwater practices seems pretty open-ended.
I think, let's have a whole stormwater conversation when we get to stormwater in 050, and then we can go back and say, does
Okay.
something need to be changed in 040 or 045?
Okay.
All right, we're ready to move on. We have 050 standards, which is a very long section. And I think we should focus on three of the subsections. We should focus on subsection J, stormwater, K, mitigation, and M, land division. So why don't we go through those first, because those are the ones we've changed, and then we can have an overall comment section. And Mike, would you like to
Sure.
lead the stormwater?
I'd love to. So there are. Oh, I'm serious.
J is all Mike's work. So
I've been living in stormwater for a long time. Let's see. So the concept in one is pretty much what we had, J1 with the last setup, but there's been an addition there. And I think it was stimulated by your set of questions that you didn't want, if a structure was going to be built upon a wetland lot of record, especially in a buffer or a protected wetland, you didn't want that stormwater to leave the wetland. Correct. So we changed the orientation a little bit to make it clear that it's our policy to keep that water that would naturally flow into a wetland in the wetland. And then, we played a little bit, actually, I don't recall that we changed anything in two. Did
no, we didn't.
No,
we got down to what we'd like to see in the water management plan. And that was really based upon experience that we've had most recently trying to figure out what the impact of moving the stormwater drain on forest lawn would do to that wetland. And as we worked through those issues, and I have to say, everybody was very cooperative. We got a lot of information that helped us get to the point where we couldn't make a decision. Where we were hopelessly deadlocked.
Not that.
But we still felt like the process was worthwhile. So what we did with the stormwater management plan is break it out to reflect the lessons learned in that experience. And yes.
Stop for just a second, Brandon.
I'm sorry about this, Mike, but I'm a little bit concerned that we have a case coming up, or I'm sorry, an appeal of this decision. And I'm just not sure where this conversation is going in relationship to that.
Well, what is always saying is we're on the documentation, we are learning from that process, that it would be more useful to be able to ask an applicant to provide us more information than not. They have already done it in that appeal. We're simply adding into here the documents that they provided that helped us make the decision.
Okay.
That's all we've done. So actually, if you want to talk about how we're using the appeal, we're learning from it in terms of just document requirements that would help us be more informed as a planning commission.
Maybe just not reference a specific space.
Sorry, I'm just not sure where this is going, and I don't want to all of a sudden.
Of course. No, I understand. I'm just wondering if we just talk about, what if this conversation was simply, here's the list of what's being proposed?
It's a list. Let me,
Explanation of why, just
yeah.
this is what's being.
I'm comfortable with that. I just wanted to
Right,
bring it up
let's
with
make
my
sure we
fellow
don't
council.
reference any particular parts, right?
All right.
Right. Just let's talk about what's here.
So now this list is broken out between two different categories of activities and uses. The one is your generic structure. And that would be 3A. And then you get down to more stormwater intensive applications, and that would be 3B. And then we would need a whole bunch of additional information.
Also, we should point out that Karen Labonte has a copy of this section.
Yeah.
And when she's back, she will have an opportunity to provide us some input on whether this makes sense to her as someone who has to actually put together stormwater management plans. So we will have an expert giving us some feedback.
So then we go down to Stanford, our standards. This is after, we've determined that this is one of those usages that requires a water management plan. How do we decide after we get all that information? That would be 4. And there are just a few things in there. One would be, we want to keep the water that would flow into the wetland in the wetland. That, I think Clay addresses your issue. It just refers to the drainage system and allows the permitting authority in the second sentence of 4A to disperse the water along a line as opposed to a point. And then 3B, we need to come up with some way to remove contaminants. And again, the structure is the same, or 4B. 4B1 is just those generic uses that represent a structure, a dwelling, a business, to help them retain the water on the wetland lot of record. They can use one of these methods or more if they want to take contaminants out of the stormwater. They're all biological. They all use natural features. Again, then going down to the more intensive uses where the contaminants may be deemed significant, or different types of contaminants, not just particulates, but maybe some solvents or oil or something like that gets into the water. Then there are more active uses into the water, stormwater, more active cleansing. Let's see, what do we call them? Contaminant abatement and removal. Then we go down to 3, and that's where we kind of say, well, okay, so we've given you these 4 options, but we don't know what's going to happen in the future because the state of this technology is changing all the time. We'll give the applicant the right to come in and propose something else, but we just want to make sure that we don't get any worse protection out of that something else than we would have gotten through one of these 4 methods. Now the standard I put in was lowest cost per unit of containment removed, but the reality is, I'm not sure that's the right standard because it focuses on cost as opposed to the amount of contaminant that goes through. So I want to rethink that. But that's what we tried to do with stormwater.
Mike, where did you come up with this, or did you get it from another jurisdiction, or how did you craft all this?
Well, I had some experience. I got on, actually, I educated myself a little bit. I went on to a couple PhD programs and looked at some of the papers that they're writing. At least you're talking about the abatement methodologies. That's what I did. The rest was just taking the structure that we have, Clay, and adding, the additional documentation that we would want to see as a planning commission to make an informed decision. So that wasn't so much of a stretch as it was experience.
Okay.
Mike, when I got to the contaminant removal, my sense was that, although I don't know what most of those things are, but it was a very prescriptive list. And I wondered if at this level, we shouldn't be specifying the results we want to achieve and not so much telling them how to do it.
Well,
The section you added on 3 kind of gives us that wiggle room. There may be another technology out there.
yeah.
So I don't know. I just thought it felt prescriptive, and
I understood that. And, you had a
Language
guy that had
not limited to, you could list them and say, but not limited to,
yeah.
that would make it less,
And I think it actually,
yeah,
I read it that you could do something else as well, but
it's nice if it says it.
really, when you get down, what I was looking for is down in C, where we say the standard that we're going to judge any of these by is, in this case, the cost per unit of containment removed.
Well, maybe we need to do some
or
research
something different.
as what into whether there's a numerical way to put that standard.
There is a way to do it. I just didn't know it. So I took I graduated with a humanities degree. I was proud of myself just understanding some of the terminology, but and we are getting people like Karen looking at it, and we will have the experts, but you know what, Les, I'd be happy to turn that around and put the standard up front. Or try to find some way in terms of, what's the precise level of particulate we're gonna let into our water? That.
Yeah, and I don't have a solution for
Yeah.
you, but in my mind, you almost would require an analysis of a sample pre-work.
That's what the
And-
management plan is about.
Something that says you can't make it any worse than what it is, and it'd be better if we could improve it, right? I mean, I don't know. I don't have a good solution, but,
That's an interesting way to.
and you're right. I mean, we are asking for requiring a management plan. Maybe that part of that contents
Yeah,
that we expect to
that
have.
was written in, and that will be part of the content that goes in.
Yeah.
Oh, there's a covenant in there, also to maintain the management plan for a period of 5 years that you make on behalf of your successors in the science too.
I hate to be the only, I caught that and I didn't know, so I don't know what the legally means, to be honest with you, but at that point, does a person have the ability to agree to a covenant? I mean, the structure hasn't even been built yet, or I
Does the person have the ability?
mean, what does it take to be a covenant? You have to,
You have to promise that whatever you put in, you're gonna.
Yeah, so it might be like, say, a condition of a permit would be, you're gonna abide by the stormwater management plan.
well, I felt like covenant was a little stronger language.
Put it in the deed
than
somewhere.
Condition of approval.
Yeah, we can change that.
Anyway.
Does anyone else have comments on stormwater?
Wait, did we get to your issues?
He's gone. Hey, he's done.
You guys?
I don't think he had any problems.
Good.
So. There he is. Should we
Uh-oh,
get him?
I should have turned the screen black, darn it.
You in trouble.
Did you have any comments on the stormwater section?
No, you guys addressed the comments I had. Thank you.
Okay. So moving on to mitigation, which is subsection K. The changes we made here were to remove off-site mitigation and clarify that the mitigation plan is for on-site mitigation. Otherwise, the section reads basically the way it was.
That's a good change.
Right.
I saw a typo.
Yeah, please.
It's not a huge typo, but section 10 of K says section 104.
Section.
Planting new vegetation.
Do we have K?
It used to be section 4 and then
Okay,
it was updated to section 10 and the 4 is still there.
really? Because mine doesn't have a 10 there.
Right. Could you read it?
Planting new vegetation in protected wetlands is permitted subject to the following standards. And then there's A, B, and C below it.
There's just no cross out of the 4 like there is in the 5 below it.
Okay, okay.
It would be page 23 total of the packet.
You should say
Okay,
Yeah.
it's down on
okay. I was still in mitigation. It was,
21.
That's still mitigation, isn't it? Isn't that same section?
that's land divisions. which
Oh, did it jump all the way to Linda?
too, but we're, no problem. We can take
Apologize.
typo corrections at the time. And that actually is a crossed out 4, but the cross is right over.
Is that what's going on? Okay.
I looked at that too and I thought, oh, why doesn't it have a cross out?
It just,
If you look really closely, there's a
okay.
dash.
A little darker.
Easy. Well, I guess it's not section 1, right? I rescind my comment.
That's right. But I like your attention to detail. That's what we need. All right, should we move on to land division? So the last time you saw this code, we had completely removed the land division section. brought it back, realizing that we need to actually specify some of procedures around land division because of some questions we got from the community. As I stated at the beginning of the night, our intention here is to not allow land division within a wetland or a wetland buffer. And I think, Les, you're the one who asked what a wetland overlay zone is. The wetland overlay zone means land that is either a wetland or a wetland buffer. So what we're saying is if you have a property that has wetland and wetland buffer on it, as well as some upland, you can't cut a line down the middle of the wetland or the wetland buffer. But you could still divide the part that is outside your wetland or your wetland buffer, provided that, of course, you can meet all of the other requirements in the rest of the code for subdivision. That is, you have enough property there to divide. So obviously this doesn't give you like, free license to just divide anything in any size. You still have to comply with basic subdivision code, but it's saying that you can't chop up a wetland or a wetland buffer. So what we needed to clarify with this portion is that when you go to do a subdivision of a property that has enough upland to be subdivided, as well as wetland and wetland buffer, we didn't want to create an unbuildable lot. That is, we didn't want somebody to come back later and say, oh, wait, there's no upland on my new parcel that was created through subdivision, and now I get to build in the buffer. So what we've added is a provision that says you have to have at least 2,500 square feet of upland, that means non-wetland or wetland buffer, included in that new parcel that has the wetland in it. Dorian, you're looking confused.
No, I'm intensely trying to.
Thinking about what this means,
I'm
right?
visualizing.
So basically what we want to make sure is that if anybody is subdividing a wetland lot of record, that every parcel that is created is buildable without any of the changes we talk about in 025. That is, without needing to do buffer averaging, without needing to reduce your buffer, without needing to build in a buffer or wetland. So that every
both parts of the subdivision, the old or the original and the new.
right. So every brand new lot that's been created still has to be buildable without any adjustments. And what this says is that once you've subdivided a wetland lot of record, you can't come back and ask for adjustments.
And that is, yeah, it's to avoid if somebody were to subdivide and make one of their lots a wetland lot of record, and they sell it, and then years later, someone comes back and says, well, you're denying me all reasonable use of my property.
Right.
Because you're not letting me build on it.
Right. Now, there is one small change we could make if we think this makes sense. And that is if we want to incentivize people who have a wetland lot of record with a wetland and buffer on it, to actually protect the wetland and wetland buffer in perpetuity, we could have a special provision that says if you are immediately protecting in perpetuity the wetland and wetland buffer, you don't need to add that upland portion to the parcel. Because it doesn't have to be buildable from now into the future if it's going to be protected. So basically incentivizes people agreeing to protect the wetland as opposed to create just another buildable lot that has a wetland on it. And so if we think that makes sense, we could add that provision here.
I like it.
Okay.
Les, I've been watching your expression. What are you thinking?
I'm an engineer.
So help us think through it then.
Oh, it's so lost,
Oh,
but I'm listening.
okay.
Tell me what we could do to clarify.
Put a formula of some kind in there. No, I like decimal points. If you
Okay.
want to do that. And I'm just trying to be funny. I am getting confused though, because I'm trying to loop back around. And so there was a point, and I'm really having a hard time keeping maybe the upland and the buffer and the wetland
Okay.
all straight in my head, but you know, there was a point where if you had 1,000 square feet in your upland, then you could build a property, and if you
Yes,
couldn't do
that
that,
was
then
reasonable
we
use.
did that.
Right.
And that, but at this point, we're requiring 2,500 square feet of upland. Yeah, and I kind of understood your explanation,
Yeah.
but that 2,500 here and only 1,000 there.
So 1,000 is really small. Yeah, this is, right.
This is about subdivision. If you're subdividing a big property,
And I know.
To be honest, this is actually very generous. So City of Corvallis requires that if you are going to subdivide a resource area, a property that has a resource area on it, so this is wetland or any other resource, you have to have buildable area on every new parcel, and it has to be much larger, like 13,000 square feet of buildable. So this is really generous to say only 2,500 square feet of buildable, because I recognize that if we were to say to the people in this community, you have to have a full-size buildable lot next to your wetland to subdivide, it would never happen. So we were just trying to bring this to a reasonable.
And I'm gonna keep thinking.
Right. Well, maybe we could draw you a picture.
We could put those examples back in, except that, and this.
I think the examples and words don't work, but in just phone pictures,
Season 2.
draw the square, cut it into shapes.
Can I take a step back? Just, I'm having my own processing challenges, Wes. I'm not an engineer, but my dad was. Robert, if I come into you and I have one of these larger sites in town, and I say I want to subdivide it or replat it in some way, what is your process for understanding if I'm a part of a wetland or if I'm in a protected wetland or a wetland buffer area?
So for that, for us to identify whether or not you're in a wetland or wetland buffer area, we would be consulting the mapping, which is based on the 1990 local wetland inventory.
So and let's just take I'm going to share my screen again, if that's okay. Can you guys see my screen now? Let's take a non-controversial site. I think the city owns this site. Can you all see that?
Mm-hmm.
If I come in and say, I want to subdivide this site, and you say what? And let's say it's privately owned.
Okay.
What is this to you? It's part of the affected tax lots?
So that is identified as a wetland affected tax lot. What I'm going to have you do is over on the legend, over under local wetland inventory, if I can have you turn the streams on. Yeah, right where your cursor is.
Is that one? Stream?
Correct.
Okay.
So at that point, we would be saying you show up as a wetland affected tax lot, and we would be looking for either a wetland delineation or a report from a wetland specialist stating we've reviewed this property and have identified that there are no wetlands on it.
Okay, so
If he drags it over, I think
Yeah.
you'll see that there's 2 streams on that, on that lot. Or
So-
maybe,
Okay, there we go. Thank you. They were hiding.
but it's not technically right now, it's not a protected wetland or a wetland buffer. In a wetland buffer area.
Correct.
It's just affected tax lot.
Correct. That's because the way that the local wetland inventory was conducted in the early 90s was that it counted both wetlands and streams, which is why you'll see these site numbers here. You see the 39, 40, and 41.
Uh-huh.
Those were actually their inventory site numbers. And so even though there's a separate wetland versus stream code, they were both inventorying the same thing. So one of the things that I would be looking for is kind of what your configuration is, how do you want to divide things out? What the stream buffers are, which I believe are 5 or 10 feet, something like that.
Okay. This is kind of touching a little bit on my concern earlier, just if I'm a crafty attorney, I'm gonna tell you, I don't have protected wetlands and I'm not in a wetland buffer area based on your code. I'm an affected tax lot, but that doesn't mean anything. If I'm gonna be really careful here. If I'm one of these properties, don't know if they're city or privately held, not picking on anyone in particular, I see nothing.
That's correct. And I don't want to get into too many details, but one of the properties you're referencing, we do have some inquiries on. There's nothing that shows in the local wetland inventory, but the property owner has acknowledged there may be something. We've spoken to them. They are going to be producing a local wetland, a delineation in order to address whether or not there is actually a wetland on it and whether or not it should be counted. But I don't want to get into too much detail about that.
I didn't, very random here. Anyway, I just think when we're talking land divisions, and we do have, you know, so few, it's hard not to pick on the obvious ones. Using language like protected wetlands and wetland buffer areas, when it does not align with these GIS map terminology, could be dicey. Might be a non-issue. Maybe there's so few of these that it will never come up. But it could.
No, from my standpoint, I completely see where you're coming from.
There's just so few. I mean, I hate to spend too much time on it when we have so few. Well, actually, that's not true. There's quite a few down here.
So
Anyway,
this is something that wouldn't be addressed through a code change so much as it sounds like there needs to be a conversation with the mapping entity, whoever that is, and the city to decide what the language is going to be and how it's going to be reflected on the map.
yes, but I still think they're married. If I'm a landowner and I want to divide my property, I come to the city and all of a sudden they're saying I'm either protected wetland or wetland buffer, and I'm saying, where's that?
Well, the code has defined that a protected wetland is in the local wetland inventory. It has nothing to do with this. I mean, the local wetland inventory is reflected, hopefully correctly, in the GIS mapping, but it is its own separate report. So that is really the authority on whether or not you're within the local wetland inventory, not this GIS map. So the person would have to go back to the local wetland inventory, which admittedly is very outdated. That's a totally different conversation, but that's really the authority. What this map says is not the authority legally.
I'm gonna stop sharing.
So are the river, was it Riverine?
Right.
Is that a completely separate section
It is.
of code?
Which quite frankly is also
Way out of date.
terrible, but
Yeah, it's way out of date.
The stream protection is a separate section of code, but they are inventoried in the same document, the 1990 local wetland inventory.
So, and that's what I was trying to kind of follow. So that example section, it was a wetland lot of record solely because of the map streams.
well, it was affected in terms of how is it related to that inventory? That inventory, because it did both wetlands and streams, means affected lots are not the same as a wetland lot of record. Because some of them relate to wetlands and some of those affected lots relate to streams. So it's just a matter of being very specific with our use of the GIS map and not assuming that it's representative of only this wetland overlay zone.
So the affected tax lot isn't necessarily wetland lots of record. They are
No.
also.
It is also stream affected. And I don't know what the name is for those lots, but
Well, see, that's the thing is that this is one of those, there's probably room for improvement things, but, yeah, they're identified as, as all being part of that local wetland inventory.
Mhm.
So.
What if we added that language? Just can't divide properties in the local wetland inventory.
Well, we've been using wetland lot of record as the term. And we have to be very careful not to say you cannot subdivide a wetland lot of record or an affected lot, because as you noticed, some of those lots are really large. And so we would probably run into takings issues if we were to say, you have a great big lot with a tiny stream or a tiny wetland, but you can't subdivide it. So
And
we
I
have
think
to be
heard
careful.
that- We did hear that concern from, I think, Mike Morgan.
Exactly. And I think that that's where we have to be super, super clear that we're not saying you can't divide a large lot that has lots of upland area. We're just saying you can't chop up the protected wetlands or their buffer.
Okay, that makes sense.
Clear as mud.
Mud part.
No pun intended.
Hey, okay, Robert,
There's a wetland.
question on this. I just was just looking, I can't find where our riverine overlay zone is in our zoning code. It doesn't appear to be one. It looks like we deal with riverine as just an enhanced buffer and a wetland.
There is a stream.
There's a section, yeah.
Wait, it's hiding. Yeah, 1771 stream corridor protection.
Okay, thank you.
Yeah, it's not up with the wetland. It's several sections down. I don't know why.
I had a question of two in subdivisions, C.
To see, yes.
Wetland buffer areas may not be counted towards base minimum zone lot size for each lot and may not be included in front side and rear yard setbacks. I'm curious why not included in front side and rear yard setbacks.
The idea here was just to make sure that we don't minimize the buildable area on the lot too much.
Mhm.
So we wanted to say, you shouldn't get to, count this as your whole lot.
You can't build a 5,000 square foot house on something that's got 1,000 feet of upland or
Mhm.
1,500 feet or whatever it is.
Okay, I guess I was just reading it. Maybe I was reading it exactly opposite of what the change
Okay.
was, because I was thinking it was not able to use that as setback, so it would force you to have a greater setback from the buffer. So you would have, the buffer's there, and then you have to do an additional 10 feet
Right, exactly, right,
depending on the side.
right.
Okay. Okay. I had a question earlier
Mhm.
too in L. Find it when I wrote it down. Vegetation management. For. Oh, where a dead or compromised tree does not present a foreseeable, this is not in the subdivisions, this is vegetation management.
Yeah.
Where a dead or compromised tree does not present a foreseeable danger to public safety or property, the city may require proof from the applicant that removal will not affect habitat as a condition of approval. I'm just curious what sort of proof of not affecting, what was sort of proof of a negative we would be
Good point.
looking for in this, because if we're essentially, we're just telling what I read it as essentially telling them, well, you need to prove that something's not going to happen if you don't do this. And so it was like a proof of a negative.
It's, you could think of it like proving that you're not going to degrade the habitat.
Yeah, I think the habitat, you're the birder, Eric. I mean, those trees.
I mean, not on my opinion of that, removing any of them is degrading the habitat anyways.
Right.
It's meant to, the dead dying are meant to decompose within the habitat.
Right, right. And so I
So
think
trying to
the
prove,
intent here was to say, if you had a specialist come in and say, there are so many snags that taking this one out won't be an issue. You know, we don't want to be draconian.
Mhm.
And this is just to make an out so that if someone comes in and they can get a specialist who says, I really feel like this is such a high quality area, taking this one dead tree out is not going to degrade the habitat. The city would be able to approve that.
Maybe saying evidence instead of proof, because proof again is subjective. What's
Yeah.
proof for one person is not proof for another.
Yeah.
Maybe saying
Yeah.
require evidence from the applicant
Yeah.
that the removal.
You have
I mean, I-
an issue too. You didn't want that log then transported out of the wetland. You would like it to be.
I would like it.
And the way that's
Yeah.
written, it would stay there.
Yeah, for in the next, the number 5, it would be.
Yeah.
Retained within the property. I was just thinking if it's dead or compromised, but not a danger, what would be, I mean,
Why would you remove it?
honestly, Why,
Right.
that was my thought process.
Yeah.
Why have these in there in the first place?
Yeah.
And then also asking for proof of a negative.
Right. And I'm not sure that number 4 needs to be in there. What do you think, Mike? This was sort of your,
The one he just read?
Yeah.
Yeah, as long as they're not taken out, I'm fine with.
because we do say elsewhere that they're not to be taken out.
Yeah, because number 5 is to not removing, they shall be left. And then number 3 is they can only be removed if they present a danger,
Yeah.
public safety or danger of some sort.
So just take 4 out.
That would be my suggestion, yeah.
That's a great suggestion, actually.
Because if it's not a danger and it's not going to damage property, then
Right.
why?
It's all covered under the other two.
And you're not allowed to build there anyways, so it's kind of.
Yeah.
Adding a ability to remove something that doesn't need to be removed.
Aesthetic.
Yeah. That's true. If you don't mind, I'm wondering if we could jump way back to F. It's one comment way back to F.
Page, which F?
Let me find this. So this is 050 F. So we are. That is really far back, sorry.
050 F. Please.
Utilities.
Yes, for utilities, correct. Underground utilities. So there's lots of mention and lots of verbiage in here about trenching. And I didn't I was wondering, was horizontal directional drilling?
You mean drinking my milkshake? You can drink my milkshake.
Was that discussed when you guys were bringing this up? Because it's frequently that is an option in places to reduce the overall impact, especially when using something like the water-based bentonite mud rather than what some oil drilling companies use, the oil-based bentonite. The water-based is much generally better environmentally. I was just wondering if that was something that had been discussed among the group.
Not really. Are you suggesting we allow it or we don't?
Suggesting allowing it as a less destructive means to the surface. So
You mean to get beneath the surface?
to get beneath the surface,
To do what?
installing new power lines, whatever for the utilities. If you have new build going into.
I would want to hear a wetland biologist's take on that. One of the things that we learned talking to, I think it was DLCD. No, actually it was Department of State Lands.
State lands.
He was explaining to us how important the subsurface of the wetland is in terms of this. There's a special base that basically means that the water doesn't permeate.
Yeah.
And I can imagine that if you were boring through that, you would create a big leak, in which case the water's going to run out and you're no longer going to have a wetland. So I would be really, really uncomfortable at this point, not having a wetland expert here saying that's actually better than trenching on the surface. So there may be instances in which that base, I forget what you called it. It was like a bowl, basically. It's
Pan or something.
Yeah.
a pan.
Yeah.
If you want to keep that pan continuous and intact, that may be more important than disturbing, say, the surface. And so that's what I would want to be sure we very, very carefully.
Yeah, and I did read a study. It was in Finland, so it's a ways away. Where they using the water-based bentonite. Bentonite is a clay substance, so it basically fills that niche of that pan. But it would be nice to hear from
Yeah, I'm just concerned.
from an actual expert.
Right. I don't think we need to prescribe that level of detail here anyway.
I just wasn't sure because it mentioned trenching so frequently, and another means of installing underground cables would be the
I
HDD.
think the hope would be that there would be no underground cables going through a wetland. I think that's really our
Yeah,
ultimate.
the object. Well, because you have
We remove the ability.
outright approval for overhead, and then underground is conditional.
Yeah, so that was intentionally to minimize the opportunities that could happen. Brian?
I have a general question, and I think I may have asked you this individually. I don't see any mention anywhere about trying to limit toxins going into wetlands from yards in the surrounding areas of wetlands. Has that been thought of and dismissed, or?
Well, that sort of segues into, I'm not going to go into the whole thing now, but the idea of having a new ordinance offered wherein we limit or actually disallow certain chemical compounds used in insecticides and fungicides within the city, even on private property. And first, when you say that, even on private property, people kind of go, whoa, but actually it's been done places and it's been done successfully. And I think, I'd really like to see Cannon Beach do that as well. And if you do have an invasive, and the only way, and this is only going to happen mostly on city property, not in someone's yard, they're not going to have knotweed in their yard, but then you could apply for a variance if you have to apply something. That's the only way you can get rid of it. But
So I love where this is going, I really do, because every time I walk on the beach and I see the water flowing.
Oh,
and
yeah.
Kids are playing in it, the dogs are drinking, and I think like,
it's going right into the water table. You put
Right.
Roundup in your yard, it's going into the water table.
But
It's going into the ocean.
but let's say this ordinance doesn't happen, for whatever reason, and we still have this code change, shouldn't we have something in this code regarding wetlands that addresses going into the
We
wetland?
kind of do. And if you look at the water,
Stormwater section of the
in the
containment.
stormwater section, it does require, if
Cleansing.
our level of particulates or the solvents going in are bad enough, you have to treat
You have to what?
the water.
And I think here's the limit of what we can achieve. We can affect what actually happens in the wetland or the wetland buffer through this overlay zone. But if it's happening outside, can't do anything about it. And I think that somewhere in one of the 050 sections, maybe in vegetation, we actually say you're not allowed to use pesticides if you're an owner of a wetland lot of record and you're there at that wetland buffer or the wetland. But it sounds like your concern is probably going to be the neighbors. And those lots we can't reach through this code, and that's why we need a citywide ordinance.
Thank you.
Yeah, and I think it's a really important concern. We need to follow it
On our radar.
Right, because I read,
Yeah, no,
Absolutely.
maybe you work on it.
yes, I would love to.
Okay. Right. Another social club.
There's got to be some payback if you're gonna have a social club. You need some booze.
Do we have any other comments? Because we've run through the sections once.
Hey, Mickey, I initially under definitions, I had thought maybe adding compensatory, I don't have the tongue this late.
Yes.
A mitigation plan would be a good upfront. You said maybe later under, is it K3 through subsection A. 3 and 4. An A under each of those. It seems like that there's reference to that compensatory mitigation plan. but maybe it should be defined up front under 3. If that's what you were meaning. In that first or second sentence.
Are you saying in the definitions, Clay? I'm not
Sorry,
following.
initially I'd said maybe we should define compensatory mitigation plan. Mickey suggested we do it later, and I think this is the later you were talking about, Mickey. But it isn't used consistently through 3A, 4A. But I think it's all what's meant there. But maybe.
And actually, you know what? I think what we need to do is remove compensatory mitigation from 4A. When we removed it
that
from,
would clean it up a lot.
right, we removed compensatory mitigation earlier and missed it in 4A.
Got it. That makes sense.
Also just removing A entirely.
Yes, exactly. It's no longer relevant if we're not doing compensatory. So that was a good catch. Thanks.
Yeah.
Anything else from anyone?
On that section or on anything?
Anything. This is your last chance.
Okay.
All on the table.
Oh, go ahead, Eric.
I think Gary's got the floor.
Okay.
Okay, I'll try to be brief. I was surprised by looking at wetland overlay and seeing that a significant portion of the wetlands are in R2 and R3. There's obviously going to be a net loss in potential multifamily housing areas. Although I'm not sure why we would put R2 and R3 in those zones originally. So I'd question the original intent there. But going from the 5-foot buffer to 50 feet, even more affected tax lots. I don't know if our rent controlled Shorewood complex could have even been built. And I'm only bringing this up because I think this is wonderful. And I love the environmental protection effort and support it. But what I would like to see us do is I'd like to see a parallel track of serious zoning discussion about how we can increase R2 and R3.
That's what we're doing with Marcy. I think that's part of the whole code audit
I
thing.
recognize, but we're, like some people have said, we're fast tracking this.
But
We've also got big housing issues.
we do, but
And-
those are going to be addressed within the next year. I mean, to try and fast track housing separate from the rest of the code when it's so wrapped up in zoning on our own.
This is the easy part.
Well, easy for you. It wasn't easy.
I can't do.
It wasn't
The
easy
tough
for
part,
us. I mean, it's.
I think, is coming in with as much passion and urgency in addressing our middle housing problem.
Yeah.
It's like, it's just not
I
happening.
totally hear you 100%. My concern is that even in R2 and R3 with the cost of parcels here and the cost of building, is that ever going to be multifamily? Any one of those? I mean, people can talk about it and I've heard a lot of talk about it. I haven't seen action. So my concern is we could spend all this time saying, let's make room for, let's wait because we want multifamily housing. Who's going to build it? It's going to have to be subsidized. The money's going to have to come from somewhere. And that's the conversation that really needs to happen. Because right now, even in those areas, I can't picture a lot that's cheap enough that someone would turn it into.
We can incentivize it.
And I think that's the conversation.
But
Yeah,
yes, and I think it's an important conversation.
for sure.
Right, you know what, Marcy's gonna take us into that public benefits discussion, where you say, oh, this wetland code. We might be able to make some adjustments here if you put in some affordable housing. And that will come, so this will fit neatly, and I agree it needs to happen, but believe me, there will be provisions in here that will probably be able to bend these rules for the right kind of housing. We just haven't seen it yet, and hopefully we will soon.
And what I'd like to see is that there's a really strong provisions that say you have to commit to this being workforce housing, you know, like in a deed restriction, not just we're protecting this and the chance that maybe, and then someone comes in and builds a $1 million home there.
I think that's pretty easy, but we got very limited R3. And this is knocking most of those off the table.
See, that's the problem is it's not, who's gonna build multifamily in R3 to begin with, right? So it's not knocking anything off the table. The houses will still go up, the dwellings. We're allowing a multifamily dwelling if somebody wants to put it on one. On one of the, and there's nothing we're gonna do to stop it. We're just trying to control how they do it.
I don't think it's an either or situation that you either, you protect your resources necessarily means that you're hurting the possibility of workforce housing. I don't see them as, as by protecting them, you're doing that because I mean, at some point you have to make a choice if you're either going to protect your wetlands or you're not. And
I agree with everything we've looked at. What I don't see is the path to really incentivizing the multifamily.
I hope that happens as a bigger picture code-wide process that this, as Mike just said, will be enveloped into. So code-wide, Marcy will say, here are the places you can incentivize. And I'm sure this will be one of them. She'll say, well, let's incentivize by allowing reduced buffers or larger areas. If you are within a buffer, maybe instead of 1,000 square feet, it's 1,500, et cetera. But I expect we need Marcy to do that big picture process.
Okay, well, I hope
you can think of this
prepared to have that conversation.
Yeah, I hope.
Just passionate about it
And I
as
really
this.
hope you keep pushing people to be passionate, because that's what we need. We need somebody like you to say every time, don't forget.
I think to address your concerns that through the code audit, there's nothing to stop us from actually rezoning. It doesn't have to be a huge area.
Yeah.
So
No.
is that what you're getting at?
Yes.
Okay.
Yeah.
Well, I'm very supportive of that.
Much less complex than what we're dealing with here, for sure.
Right.
I think.
Never say that. And that.
Zoning tends to be very. It takes a lot of time. There's a lot of meetings involved.
We're good at that.
Just a little
Just
soapbox thing.
practicing.
Yeah,
There are lots of big things with the code audit and our housing problem is a problem.
it is.
Yeah.
Very
And
much.
we know that.
I don't think we can solve it tonight.
No.
No, but we do need to continually remind us.
Absolutely.
And we will. Okay. Well, I would like to thank the social committee for the amount of work that they took. And I think we really are ready to go on to the next step and have the experts look at them and thank you very much.
But thank you all for amazing, careful reads and great questions. It's incredibly helpful.
Okay, so anybody have anything for good of the order?
well, I do. I just wanted to say that I found out today by doing some research, Vicky's suggestion actually, that there is a designation of bee city. And in Oregon, Eugene was just named a bee city. They did the appropriate work. It's where you do things in your community to encourage bees to, the kinds of plantings that will make bees want to live here. And you also get rid of the pesticides that kill bees. And so, and those are the two of the main things that you do to become a bee city. Ashland, Oregon is also a bee city. And so there's a whole they say that the first thing you should do, they suggest on their website, the Bee City website, is that you form a little group who will start working on becoming a Bee City. And so
Oh, be social.
let's be social. Yeah, I love that.
Bring your own bee.
Anyway, I think that would be a great idea to look into it, what would it would take. But I also think that drafting an ordinance and it's nothing as complicated as this. There's no way. It's very simple, actually. And just like the one from Baltimore that I circulated, you know, the actual language in the ordinance, it's different than ours would be because they're a much bigger city. But ours would be simpler. But I just think that that's something we should move forward with. And I mean, if anyone would like to work on that, I think.
Can we do it in tandem with what we were talking about doing?
Yes, that's what I was thinking.
I would be very.
Okay, that'd be great.
Now you're talking in secret code.
No, no, he's not. No, he's just saying with in tandem with working on a bee ordinance. I mean, a pesticide,
Oh,
herbicide.
gotcha.
ordinance.
Okay.
Yeah,
Yeah.
One another.
Definitely.
very much. Yeah,
Yeah.
right.
Okay.
So I'll put my thing in for the 12 days of Earth Day. There's going to be some really good pollinator information, pollinator gardens at the street fair.
Good.
On Saturday,
Good stuff.
Excellent.
When was Shreds? I missed that.
Friday,
Friday,
10.
and they'll do, yeah.
Yeah, I was telling Mickey today, they used to have in Seattle, they had a backyard garden designation you could get for your house if you committed to not using herbicides and pesticides. And
Oswego has something similar.
yeah,
In terms of, it's also, how many plants you have that the
Right.
birds and the bees will come to.
but it's like a positive spin on thing, not saying you can't do this. It's like saying, do this.
And you get a
And yeah.
fact that you can put. in your
Yeah.
backyard.
The National Wildlife Federation has a backyard certified backyard habitat sign that you can
That's-
put up, and
That's what it is.
Portland Audubon also has something that's a similar certification, but they don't patrol this far out unless you're really nice and friendly and ask them very carefully.
It'd be really, it's a great positive way of incentivizing people rather than just yelling at them about what they're doing.
Good. Okay, anything else? Well, once again, thanks
Thank you.
and meetings
you all.
adjourned.
Thank you.
Not everyone.